Is in session. The Honorable Circuit Judge Bradford Winstonworth presiding. It's been a while since we've done this. It's nice to have everyone here. This is a matter of the state of San Andreas versus Chorley Chobot, and more to the point, Mr. Tyler Brown. This is an arraignment and other pretrial conference hearing. State, could you please, Miss Day Hilliard, are we good to go? She may be thinking. We may do all that over again in just a second.
There we go.
Do you have a clean copy, Miss Dayhiller? Do you need me to start over?
I think we are very close. It should be good. At least you want to start.
I'm just gonna do it again. I'm gonna do it again. All right, here you go. This it'll be fun. All right, court is in session. My name is Circuit Judge Bradford Winstonworth. This is the matter of 2024 CM 356, State of San Andreas versus Chorley Chobot and Tyler Brown. Mr. Chobot, I understand, is still in custody. We'll work that out later with the state. But Mr. Brown, I understand, is present in court today and is pending arraignment. So this will primarily be an arraignment hearing as well as a pretrial conference to handle any other pending matters. Counsel for the state, can you please introduce yourself and state your name?
I am Senior Prosecutor Magnus McCready with the San Andreas Department of Justice. I am first chair in these proceedings.
Oh, wonderful, wonderful. All right, and for the defense, counsel first.
Assistant Public Defender Kathleen Montoya, first chair, Your Honor.
Aren't you technically state public defender-elect or something of that sort, Miss Montoya? Congratulations, by the way.
Thank you very much. You could refer to me as such, but I prefer to go on my acting title.
What does that mean? No problem. No problem. And then the defendant, please state your name for the record.
Yo, what's good, big man? Fucking name's a little porta potty.
Could you state your legal name, like the one that it says on your ID?
Fuck yeah. Like, don't go around like spreading it around or shit, but it's Tyler Brown.
All right, thank you, Mr. Brown. You know, as we discussed outside, I'll be happy to refer to you as Mr. Potty. I would ask that you mind your potty mouth in court, however. Just be considerate of the fact that this is an official court proceeding, okay?
Oh, heard, big dog. I'll do
All
my
right, thank
best.
you very much. Thank you very much. All right. Pending is the arraignment of Mr. Potty. There's a matter that we'll get to later in terms of how this was handled that I believe counsel are aware of based on conversations with both counsel present before court adjourned today, or I guess before court came to session today. But let's start with the defense. Actually, let's start with the state. State, could you read out the charges that the defendant's being arraigned on, just to confirm?
Absolutely. It's 4 counts of aggravated second-degree murder.
And just for the benefit of everyone involved, as well as the recording, that is full murder, right, Mr. McCready?
Yes, that is full murder in the second degree in aggravating circumstances.
Perfect, thank you. Defense, at this time, Mr. Potty, your lawyer here is with you to help you plead to these charges. I understand that officers asked you to plead earlier. That was incorrect, just for the record. So you have an opportunity to give a plea now, and I understand that your counsel has taken the opportunity to explain your options to you. At this time, I would like to hear your plea, Mr. Potty.
Yeah, of course. You're Mr. Glorious, Expeditious Honor. May I make one simple remark?
Oh, certainly, Mr. Potty. And just Circuit Judge Winstonworth is fine.
Sure. Yeah, whatever you want, OG. So, like, they made me plea. Like, they forced me to plea. They said I had to. They also, like, they already fined me and things like that. I don't know if you were aware, but I am $80,000.
Did they really?
Yes.
Did they really?
Just for clarification, he was fined for the charges he pled no contest to. Which
no, it was
was
40 grand. Oh, was it? I don't know.
I can double check. 1 second. There's no set
let's sort this out.
There's no set amount in the MDT for murdering, Your Honor, so there's no way he could have been fined for it.
Oh, shit.
Oh, sure. That's fair. Well, let's make sure everybody's on the same page, just so Mr. Potty can be aware of what's happened so far, because it seems like he may be a little bit disoriented.
Yeah, well, look here.
I think it's important to educate our individuals present in court.
Yeah.
I've been locked up for a while. I'm all discombobulated.
So,
understandable, Mr. Potty.
It looks like he was find. Yeah, so he got a $42,000 fine, 42,500. It was 4 counts of aggravated attempted second-degree murder on there as well from a separate incident. 1 count of robbery, 1 count of unlawful possession of a Class 2 firearm, and then it was also 1 count of terroristic threats.
Oh,
So that'll be
I
where
see.
the majority of the fine came from there. So I believe it was 20
yeah,
for
that would do it. That
I
would
believe
do
it
it.
was 20 for the 4 counts of attempted second degree murder, and then 20 for the terroristic threats as well.
Certainly. All right.
Moving
Wait, so
back,
you're saying that's 40 altogether, though, right?
42.50.
So I was
Mr.
charged for the
Potty,
murder.
the terroristic threats is $25,000
Oh,
all
that's
on its
right.
own.
No, correct. What I'm saying is I was charged 40 grand overall, though.
Oh yes, but not for the charges that you're being arraigned on today. Just to be clear.
Oh,
Yeah,
okay.
and just for clarification, he was also charged 2 counts of aggravated attempted second degree murder for the initial store robbery, which this docket stemmed from, 1 count of unlawful possession of a Class 1 firearm, and 1 count of robbery, which was an $8,500 fine, which adds up because the attempted second degree murders and the aggravating circumstances were 4,000 apiece, and then the subsequent unlawful possession and robbery would have equaled out to about 500 as well.
It does sound like he's had quite the busy set of circumstances recently. Does
Yes.
that answer your any pending questions you may have had, Mr. Potty?
Oh, I think so.
All right, wonderful. So at this time, you're being arraigned, as Mr. McCready said, on 4 counts of aggravated second-degree murder. That is full murder. So we are here to hear your plea. Please state your plea for the court.
I plead not guilty. It's manslaughter at best. Those pussies deserved it. I'm sorry.
Ms. Montoya, does your client understand that manslaughter? Actually, hold on.
No, I don't. I can answer that, Your Honor. I have no idea what it.
We do have manslaughter charges in this state. I guess I've just never seen them charged. All right.
We have vehicular manslaughter.
Well, we also have voluntary and involuntary.
That's true.
I mean, I
just
cried
don't
when
think
I
I've
did it.
ever. I don't think I. All right, let's let your counsel speak for you, Mr. Potty. I just don't think I've ever seen manslaughter charged, but that's all right. Ms. Montoya, does this plea reflect what you're prepared to proceed with?
It does, Your Honor, yes.
All right, so he's entered a plea of not guilty, which means it's time for bail. How does the state feel about bail?
The state would ask that bail be denied due to the grievous actions which he is accused of. It's 4 counts of second-degree murder, which is quite heinous in nature, and I feel like it would be quite dangerous and disrespect to the public trust and safety to release this man on bail.
Do we have any information, Mr. McCready, about the nature of the murders?
Yes. As far as I'm aware, it was during a store robbery.
Yeah,
It was.
what happened?
They were shot.
I see. And do you understand why they were shot?
I have not.
Allegedly?
I struggling to talk with the officer. To be honest with you, it's quite hard to reach him sometimes. But from my understanding,
Is that Mr. Takai or Mr. Merlin?
Takai, give me a second, and I can get. Looks like there was already the locals were already dead.
By the time the officers arrived.
Yes.
Okay. I see. All right. I just want the debrief was not clear in my opinion about the timeline of all of this. But I've also been focused on making sure that we could get Mr. Brown arraigned. So I'm sure that everything will be established as we proceed. Ms. Montoya, how do you feel about bail?
I believe given the circumstances, bail would be appropriate. Mr. Brown, or Mr. Potty, however he wishes to be referred to, does have his father here present with him. he does have family here tying him to the state. He would be unlikely to abscond. And given the circumstances of the charges presented to him, I am sure that there would be reasonable bail conditions imposed upon the defendant that would satisfy the question of public safety.
Ms. Montoya, is it your opinion that monetary bail would be sufficient to incentivize the defendant to, be on good behavior and appear in court?
That is my understanding, yes, Your Honor.
Okay. And have you conferred with him about whether he has the assets to support bail?
Having just confirmed with the client, as much as it is my belief that I believe monetary would be an incentive, he does not have the funds, unfortunately.
I think that's going to be a problem for us, no matter how we proceed. Mr. McCready, hypothetically, we'll come back to the conditions, but what amount of money would you want him to be on bail for?
Well, it is 4 counts of murder, Your Honor. So it would have to be a very highly incentivizing amount.
Well, that's shocking. That's just absolutely revelatory. Give me a number.
45,000, Your Honor.
45,000. And if I'm correct, isn't that the amount of money that you asked to be the fine for Mr. Chobot?
Give me a second. I believe it was.
I'm pretty sure that's the amount of money that I fined him for.
Yeah, it's exactly 45,000. Yep.
I think that's pretty fair. Miss Brown, I'm inclined to issue bail at the amount of $45,000. Is Mr. Brown able to make that payment?
He is not presently, Your Honor, no.
All right. Let's handle conditions then, at least. Mr. McCready, any additional conditions to the standard 3?
Yes, Your Honor. No firearms. Search without probable cause, but with present reasonable suspicion. And additionally, we'll do 3 check-ins a week with law enforcement, please.
Let's come back to the probable cause. What's the basis for the request there?
It's because Mr. Brown has been found in possession of illegal firearms numerous times throughout his crimes. So it's the state's belief that he would continue doing so.
All right, Ms. Montoya, thoughts?
I believe that would be improper, Your Honor. Simply imposing a condition that would prevent him from legally being able to possess firearms, I believe, would be more than enough. I do not believe that the charges presented against the client today are sufficient enough to constitute a allowance of violation of his rights as a bail condition.
Mr. McCready, I'm inclined to agree. If he's not allowed to have a firearm on him, that's probable cause for a search if officers have reason, probable belief that he's in possession of one, is it not?
The state would disagree, Your Honor. I mean, law enforcement would tend to only really believe he's in possession of firearm if he is in, like, let's say, in the immediate area of shots fired, for example, right? I mean,
this guy's never talked.
Well,
to a
I mean,
cop
they could
before.
frisk him, right?
I mean, they could, but they would need.
And if they felt a weapon, that they could then search him.
They could frisk him, but they would need to act under Terry versus Ohio, which means there would have to be a present and open belief of threat or danger, whatever the case law says.
What I'm really curious about is whether Mr. Potty here is likely to reoffend while he's on bail. You have anything to say to that?
I don't think I could get on bail, dude. I'm $80,000 in the hole.
Mr. Potty, I understand your position, but I want to make sure your rights are vindicated if you do manage to come up with the funds.
Come up with the. Who do you think I am? My music is dog shit, bro.
Well, you have your father sitting behind you, so I'm not going to assume anything. Listen, it's important that we go through this process. It's your rights, Mr. Potty.
Dad, can you spot me?
Your Honor, state has one final statement on that condition.
Yeah, of course, please.
I mean, it's been established in the past as a condition for people who have been in possession of illegal items. and that condition has been applied. We don't think it would be any different in this case with the illegal possession of a firearm. He's shown time and time again that he can be in possession of something illegally. As such, we would request that that condition be added.
I have a counterpoint to that.
All right, Ms. Montoya, last word.
Nobody's ever told me no.
Your Honor, I believe that the circumstances for a search with RS and not PC would be perhaps applicable in a situation where the defendant were being charged with drug-related offenses such as contraband, intent to distribute, possession. However, that is not the charge that is being presented against my client, and therefore I believe that a statute of no firearms would be more than applicable.
All right, one more question. Just because I'm not sure I have all the details on the docket. Mr. McCready, you said that he had a second or class 2 on him that he was charged for.
Yeah, so that was the incident from which he was arrested from. He was
A
found
separate incident.
Yes, he was found in possession. Give me a moment while I have a look.
Chief Justice Gupta, if you could come up to the bench, I have a procedural question just to ask you on the side.
Hi, Gupta. He was my lawyer once.
Your Honor, just
Oh yeah, go ahead.
so it is a class 2. I'm not seeing in the report what it was exactly. But obviously with it
Did
being
he
a
plead
class
to
2,
it?
he did. He pled. I believe this was. He also
think he was
pled no
guilty.
contest to this one.
I don't
I see.
mind
All right,
telling
thank you.
Judge what it was.
No, I'm gonna let your attorney speak for you, Mr. Potty.
Okay, it was Samuel Davidson's shotgun I stole from his car because he was being a little bitch.
Mr.
Oh, okay.
Potty, I can hear you, but
Well, I can
yeah.
hear you too, unfortunately. You look like you belong in Peaky Blinders.
Okay.
Sorry.
Yeah, it looks like it was a stolen shotgun, Your Honor. Just based on the reports on his profile. He's actually at the very minimum, the last 4 reports on his profile have included illegal firearms in his possession, Your Honor.
Bro's not even wearing socks.
Either way works.
All right, here's what we're going to do. I'm not going to rule on the conditions today. What we'll do is we'll reevaluate them. So, Mr. Potty, I'm going to set your bail at $45,000. If you determine that you are able to make a payment of that amount, then we can certainly gather everyone together for another hearing, at which point we'll figure out your conditions and get you released on bail. I think that at this time, it's reasonable to consider that circumstances may change in the future and that we should issue conditions at the time that payment is possible. So $45,000 will be the amount. That'll be reflected on the docket so that if you are able to pay, you can notify your attorney or a member of the DOC and we'll get something figured out about setting up a hearing. Does that work for you, Ms. Montoya?
Yes, Your Honor, it does.
All right, wonderful. Mr. McCready, any concerns with that approach?
No, but we do have a motion to make.
Certainly. Let's hear the motion.
Due to the length of time that is taken to complete the arraignment of Mr. Brown. The docket was filed on, let's see here, the 19th. Yep, the 19th. It is now the 2nd, which...
Yeah, I'm aware of the timeline, Mr. McCready.
Yeah.
I think I commented on this on the docket. What's the motion?
We are requesting an additional 7 days continuance to allow the state to prepare a fair case against the defendant. We believe that the remaining time will not be sufficient enough for the fair trial on the part of the prosecution and will result in prejudice in some
Well, the STA date is 9 days from now. Are you saying that you haven't done any prep for this case whatsoever and have assumed that it would be, you know, a plea until this point?
No, Your Honor, I have the evidence. It's just I think it would be best suited that we have an additional couple of days to get more witness statements and everything put together.
What do you need, Mr. McCready?
I need 7 days, and that's about it. I don't think 9 days.
No,
is
no,
going to
I
be...
understand the 7 days. That's fine. What is remaining to be conducted that the state needs that it wasn't able to get during this time? Because mind you, you also had. Sorry, we actually have an additional 3 days because of the court closure. So it's going to be the 14th is the STA date. So is there something specific that you haven't been able to get in the time so far that is required for the purposes of having an extension here?
You know what? If it's the 14th, we're all good then, Your Honor, I think. Because that gives us some extra time. I think that's feasible.
I am inclined, by the way, to grant a continuance. I said that I would if it ends up being necessary. I just don't want to put the cart before the horse. I think it's appropriate that we go to trial fairly quickly on this. I think everyone's sort of understanding the nature of the case and the circumstances. And to be quite honest with you, Mr. McCready, given that the officers chose to pursue this matter and that, you know, the nature of the charges, I would be shocked if they hadn't already begun preparing matters for your attention. I understand that may not be your fault and that you may have been diligent in trying to acquire those matters, but it is a joint effort from the state and the police to produce, you know, all required evidence ahead of trial. And arraignment itself, I mean, you knew this was coming, and it is a little bit actually, it's entirely law enforcement's fault that we had to figure out what was going on with this case so that we could get it set for arraignment. Mm-hmm. I do take ownership of some of those delays, don't get me wrong, which is why I'm willing to issue a continuance. But I don't think anyone should be surprised by the need to substantiate a case with evidence, especially in the case of murder. Is that fair, Mr. McCready?
Oh, totally. I tell you what, Your Honor, I will withdraw my motion for the time, and I will revisit this in a couple of days. When we're
if it turns out that you have, you know, witness availability issues, like there was some compelling reason, and if you need to provide it via sealed email or something, that's you know, the standard stuff. I'm sure you're used to it from your time as judge as well. I'm not here to cause anyone headaches. I just want to make sure we're proceeding swiftly. Does that make sense?
Yeah, absolutely.
Ms. Montoya, any concerns?
None presently, Your Honor. If there are additional motions for continuance that are made on the docket, we can address those as they come forth.
All right, wonderful. And if the parties want to stipulate, that's fine. I just want this case to go to trial.
Yeah, absolutely. I will let the court know if we are looking at requiring more time, and then obviously we'll substantiate with a reason as is required.
All right, wonderful.
Yeah, that should be us squared away for the moment, Your Honor.
All right. Any other pending motions before the court addresses some sua sponte concerns? Mr. McCready?
No.
All right, Ms. Montoya?
Nothing from the defense, Your Honor.
All right, wonderful. Is that State Attorney Doc Hilliard present in court today, gracing us with his presence?
Absolutely.
Oh my goodness, it's so good to see you, Mr. Hilliard. I'm so sorry that I missed your swearing in. You know, we're all very proud of you. Mr. Hilliard, this next matter concerns the Department of Justice, and I'm wondering if you might step forward and assist Mr. McCready. He hasn't done anything wrong, don't worry. In fact, I think you might both be very helpful.
Absolutely. And it should be of note that I also missed my swearing in.
Oh, wonderful.
I like that guy.
All right. Mr.
I like
McCready
you
and Mr.
too.
Hilliard. I was speaking with Mr. McCready before court. Mr. Hilliard, are you aware of the circumstances of this docket?
Absolutely not.
So sorry for the interruption. Is everyone able to hear me?
Mm-hmm.
Yes, Your Honor.
Hello?
Yeah.
Hello?
Hi.
Oh, perfect. All right, great. So sorry, as I was saying, Mr. Hilliard, are you aware of the circumstances of this docket? This is CM 356.
Absolutely not.
No. Okay. Well, something interesting about this docket that Mr. McCready actually identified, and is very eagle-eyed of him, is that officers asked and took a plea from Mr. Potty here on 4 counts of aggravated second-degree murder. And I imagine you're familiar with the correct process for that, aren't you, Mr. Hilliard?
I'm sorry, they took a plea for which charge, Your Honor?
Aggravated second-degree murder, 4 counts of it. That's full murder for you, Mr. Hilliard.
Really?
Yeah, they took a plea of no contest. They even noted it on the docket. Isn't that interesting?
Well, let's see, Mr. Teko filed the indictment. It's very par for the course, I see.
Said well, I'm not going to comment on that. I don't think that would be appropriate under the circumstances. But both suspects admitted and quote, both suspects admitted and has already pled no contest to 4x aggravated second-degree murder, and is held at Bolingbroke pending arraignment. Do you see that, Mr. Hilliard?
I'll see that in the last paragraph. That is correct.
Yeah. So, is it your understanding that that is correct court procedure, Mr. Hilliard?
It is absolutely not.
And you're well versed in the court procedures, aren't you, Mr. Hilliard?
I suppose.
I mean, you are a justice of the Supreme Court. I would say that you are personally. And Mr. McCready, would you say that you're also well versed in the court procedures?
I would say so, just a bit, yeah.
All right, now, Mr. Hilliard, I was actually reviewing some recent dockets, and I found that in a civil matter, the Chuck Wilbert case, you declined to impose remediatory classes for officers on the basis that you weren't sure whether there would be an opportunity for those classes to be conducted. So I'm actually going to ask for your help today, because I understand that you, Mr. McCready, are experts in criminal procedure and the procedures of the courts. And I'm wondering if you might be available to help run some classes for the officers involved in this matter about the appropriate procedures relating to murder charges. Is Mr. Schneider okay? I just saw him fall over.
He's fine. He's fine.
Good, Your
All
Honor.
right,
I
great.
just
Matt Murdank, it's okay. You're all right, Matt.
All right, Mr. Hilliard and Mr. McCready, do you think you might be willing to help facilitate some education for these officers?
Absolutely 110%.
Because I think that does resolve. Oh, go ahead, Mr. McCready.
I think I can adopt that with 120%, you know, quite frank.
Oh my goodness! Should we get into an auction?
No, absolutely not.
Okay, all right. I think Doc could outbid you just to say. But I think that resolves the operative concern that was the major blocker in the Wilbert matter. Wouldn't you say that, Mr. Hilliard?
I also felt as if the court did not have the expertise in administering the training. So yes, there were 2 reasons.
All right. Well, in this case, I'm comfortable delegating that administration to the Department of Justice, seeing as you all work with officers on a regular basis. I should hope even daily. And so I'm inclined to issue sanctions. I'm not trying to cost anyone their careers here, so I'm not even really going to cost them any money. But I am going to ask that they attend a remediation class with you both about appropriate court procedures that lasts at least 30 minutes, but as long as you find discretionarily appropriate. Is that something that you both would be able to support?
I completely and totally support that.
Yeah, just like the Constitution, Your Honor. I approve.
Oh, I love the Constitution, personally. All right, Ms. Montoya, for this, let's say infraction of court procedure, because Mr. McCready didn't want me to call it a violation of your client's rights. Does this satisfy the defense in terms of remediation measure?
In this immediate scenario, yes, Your Honor, it does.
All right, perfect. I do find that it was a harmless error on the basis that he did get sent for arraignment and was not charged for, not billed, shall we say, for the charges at issue, which I suppose was technically not possible given that they are judicial discretion. So we would have found ourselves in the same position anyway, but it nevertheless should not have happened, and he should not have been confused or placed in a circumstance where he was obligated to plea for charges that require an arraignment, because that is, of course, the entire purpose of an arraignment. And I trust that you gentlemen will do an excellent job of training the officers involved. I will say it doesn't have to be all at the same time. We'll figure out exactly who is involved with this. I'll work with you after court, and then I'll issue an order indicating who should be obligated to attend. And we'll figure out the details. So that resolves that matter. And that was a sua sponte item I wanted to address. And then I also just wanted to say, because of the officers' lack of care on this matter, that was partly why we had the delay in getting to an arraignment in the first place, because we had to figure out exactly what had happened, the nature of the charges, whether this was a paperwork error, things of that nature. So I'm happy that we were able to get this all done tonight. I think it's been quite productive. Before we conclude, I'll ask whether, Mr. McCready, you have anything further?
Not this time, Your Honor.
All right, wonderful. And Ms. Montoya, anything from you?
No, Your Honor.
Oh, hold on, Your Honor. Actually,
go ahead, Mr.
while we are here, the state does have two motions, or one motion for subpoenas, if that's something you would be inclined to
I think we
entertain.
can deal with any potential subpoena issues and things of that nature while we're here. Is that all right with you, Ms. Montoya?
Absolutely, Your Honor.
Actually,
All right,
make that two. So first things first, the state would subpoena Officer Kenji Taki and Director Merlin Savage, as they are directly involved in the incident relating to the indictment. They are first-hand witnesses and key to the prosecution's case.
All right, thank you. Any objections from Ms. Montoya?
No, Your Honor. We would similarly motion to subpoena both witnesses for the defense as well.
You would move to subpoena both. Excellent. Yes, I'm going to grant those subpoenas for both individuals, for both sides. I think that's very fair. Wonderful. Anything else, Mr. McCready?
Absolutely. The state would also subpoena the local coroner's office reports on the 4 victims in this case. As it's my understanding, they were locally transported by a local coroner.
Of course. Ms. Montoya, any objections?
No objections from the defense, Your Honor.
All right, that's granted. Anything else, Mr. McCready?
No, nothing from the state at this time, Your Honor.
Wonderful. I'm going to ask Mr. McCready that you evidence these motions on the docket, and then I will grant them in the order that I issue. Does that work for you?
Yep.
Perfect. Anything pending from you, Ms. Montoya?
No impending motions from the defense, Your Honor.
Tremendous. All right, so here's what we're going to do, just to summarize. Mr. Potty, you will be remanded to Bolingbroke until trial. If you're able to come up with bail in the amount of $45,000, then we'll reconvene ourselves, potentially virtually, to, via email, I should clarify, to determine your bail conditions. And at that point, you would be on bail. But until that time, you will be in Bolingbroke until trial. And we will look to go to trial before, ideally, December 14th. If a continuance is necessary, I'll expect the party moving for such a continuance to state with detail and clarity why they are not able to obtain evidence or otherwise prepare themselves before trial. And we'll look to get a scheduler out in the near future, given that we just resolved subpoenas. I think it's very productive pre-trial conference. Very, very productive. And furthermore, I want to thank the state, the members of the DOJ, Mr. McCready and Mr. Hilliard, former esteemed judges, my former colleagues, for being willing to support the education of our esteemed law enforcement officers and their ongoing commitment to justice, court procedures, and ensuring that defendants' rights are not violated. Thank you all for your time. Court is adjourned.